Good morning. 36th District Court in the state of Michigan is now in session. With the Honorable Donald Comer presiding. While court is in session, there'll be no talking, speaking, chewing of gum, or reading any materials, and please no driving. Thank you.
All right, this is case number 06145-241. This is Andover Financial LLC versus Betty Caruso. The matter is before the court on the following objections to a writ of garnishment as it relates to the Michigan Department of Treasury. The judgment in this matter was initially entered on the 28th of December 2006. That judgment was subsequently renewed by this court on the 6th of April of 2016. This garnishment is an effort to collect on the balance of that judgment. All right, your appearance for Andover Financial LLC, please.
Good morning, Your Honor. Dawn Blair on behalf of the plaintiff P62601.
All right, thank you, counsel. Good morning to you. I'm looking for Betty Caruso in this matter. If you're on this Zoom, please say something at this time.
I'm Betty Matthews. I don't know who Betty Carson is.
All right.
But they did take my money.
Your Honor, if I...
Well, let me get everybody on the record first. Okay, so you're Betty Matthews, and you're the one that filed the petition regarding this matter. Is that correct, ma'am?
Yes.
All right, thank you. Madam Counsel?
I was just going to inform the court. My intent is to release this garnishment. The individual that is present in the courtroom that filed the documents, her name is Betty Matthews. My defendant is Betty Caruso, and Miss Matthews that is here with us today has indicated that she's never been known as Miss Caruso. The state of Michigan does base the honoring of a tax garnishment off of a social security number. And so it would be my understanding that the social security number that I have, that I provided to the state of Michigan, belongs to Miss Matthews, not Miss Caruso, and that we do have probably an issue with regard to the social security number that we believed to belong to Betty Caruso, but actually belongs to Betty Matthews. And that's why Miss Matthews' tax refund has been held, which certainly we don't want to take funds that don't belong to the individual that owes this judgment that you have in front of you.
All right. Given that set of circumstances, as you've articulated, counsel, it would seem reasonable and the right thing for this court to do to find that the objections in this matter are valid and that the funds should be released to Ms. Matthews. Obviously, if at a future date you should find that these are one and the same people, you always file appropriate paperwork in that regard. But given that there's no evidence that these are one and the same persons, that releasing the garnishment will be the proper thing. So, Ms. Matthews, I am signing an order finding your objections valid and releasing any withheld funds to the defendant in this matter. That would be to Ms. Matthews, and I'll make that clear on my order. You'll get a copy of my order in the mail, Ms. Matthews. Also, a copy will be sent to Michigan Department of Treasury as well. All right, all the best to you. Thank you, Counsel. Good day to both of you.
Thank you.
Thank you.
This is case number 20144-773. This is Albion Funding LLC versus Keisha Aldrich. The matter is before the court on the filing of objections to a writ of garnishment regarding the Michigan Department of Treasury. The record should reflect that the judgment in this matter was entered by default on the 8th of February 2021 for $2,675.57. The garnishment is an attempt to collect on the balance of that judgment. Your appearance for LBNB funding, please. LBNB funding, if you're on the Zoom, please say something at this time. Or do I have Keisha Aldridge on this Zoom?
Yes, sir, I'm here.
All right, thank you, Ms. Aldridge. I note that your objections indicate the writ was not properly issued because I was not notified of the debt or given the option to properly handle it in a timely manner. The file in this matter would reflect that the judgment was entered by default after there was no response to the complaint. That lack of response was secondary to an order of the court that allowed service by alternate means, by posting and tagging at an address on East Grand Boulevard in the city of Detroit. That form of service is allowed by court rule, and that is the basis upon which the judgment was entered in this matter. If you wish to attempt to get the judgment set aside, you have to file an appropriate motion to do that. The matter that you bring before the court at this time is a post-judgment matter, meaning that this is after the judgment was entered, whereas the issue you seem to raise is an issue before the judgment is entered. The court rules do not allow me to deal with pre-judgment issues in a post-judgment hearing. So you have to go back and try and get that judgment set aside. Right now, there is a validly entered judgment that allows for the execution that has been presented to this court. All right, I'm just looking through the file to see if there's anything else that I can bring to your attention. I do notice that there is a notice of judgment lien that was issued back in March 21, 2023. And I also know that there have been a series of writs of garnishment and attempts to collect on this judgment. Let's see, back in 2023, there's been a garnishment with respect to Chase Bank. There was no money there though. All right, so that's kind of the history here. You got a judgment against you, and as long as that judgment is out there, the plaintiff has the right to collect on that judgment. The issues that you raise are issues that you could potentially put in the form of a motion to try and get it set aside. But I can't address that today because that's not before the court. The post-judgment stuff is before the court. Now, let me point out one other thing. One second. So yeah, this started out with a bill that relates to Care Credit Corp dental account. Then Synchrony Bank was the one that had that particular debt. Then Synchrony Bank then sold the debt to LBN Funding. That's the genesis of all of this. And then it was brought to court, and attempts were made at service, and when the plaintiff was not able to effectively make service, they petitioned the court for alternate service, and the court allowed them to serve it by first-class mail and by tacking at the address as indicated. A proof of service in that manner was filed with the court. So again, you still have the right to file a petition to try and get the judgment set aside. As long as that judgment is in place, the plaintiff has the right to go by way of garnishment and attempt to collect. All right, anything further you wanted to bring to my attention, Ms. Aldridge?
Nothing that will help resolve the matter. Thank you.
Yeah, that's kind of where it is right now. Have you reached out to anybody over at LBNB to try and perhaps get this set up in some kind of way where you can at least you could be moving forward trying to get it financially resolved, and then if you are able to get it set aside, any money you pay out would ultimately be refunded.
Oh, yes, I have tried to contact them multiple times. Even of the day when I went to file the paperwork, it was some information that I needed to get from them. I'm not getting an answer. I've even called their attorney. He's based in New York, so I had no communication with them.
Yeah, I do see the attorney based in New York. All right, now that's the best that I can tell you right now regarding this.
Your Honor, I do have one question. The form that I need to file for the motion, what exactly is that called again?
You can do it on the form, or you can do it on any kind of paperwork. I don't know that there is a quote unquote form for it, but it sounds like what you want to do is file something called an attempt or motion to set the default aside. The judgment was entered by default. You want to file a motion and attempt to set that aside. If in fact you had a debt with Core Dental that went to Synchrony and then ultimately was sold to LBNB funding, then filing the motion might not be the wisest approach. The wisest approach may be to reach out and figure out if there's a way that you can compromise the debt and try to pay it off. So you have to think about all those things. I don't know. That's why I went through it to tell you what the genesis of all of this is. And given that, and I move on to some other cases, but given that they have a lien on your income tax return, that may be a negotiating chip to try to get it resolved. Now, how much money are you expecting back from the state?
It was 2,200 or 26. I think it's 26.
So the debt here is in the nature of 2,600. At least as of 2021, that's probably gone up some with interest. I do wish that the other side was here, because a lot of times if they're present, we're able to put you in a breakout room and talk about this thing and see if some compromise can be had. I don't have the other side here. So I'll have to, so let me do it this way, Ms. Aldridge. Let me go ahead and adjourn your hearing for a couple of weeks. I'm going to send another notice to the attorneys to see if I can get the other side to come in on this and see if there's any room to try to figure out a way to deal with this. So, otherwise,
thought that was Mr. Rusley's case, but that's in Mr. Steers.
George, Deb, you thought that was Mr. Rusley's case, right?
Yeah, I did. I thought it
I
was.
thought 328. That's what I thought.
I said Joshua Steer on this.
Oh, okay, all right.
But
Because it's so old.
if she'll hold tight, let's see if Mr. Rusley.
Because he was here, but I thought he said
That's what I
this case,
thought.
the system, I could swear it was 328.
All right, well, why don't we do this? Why don't you hold tight for a moment, and we're gonna reach out to a lawyer that handles cases for LBNB funding. And
Well,
see
Miss
if
Francis, Judge, maybe.
on Ms. Francis.
Yeah,
All right,
maybe.
so, well, we're gonna check with a couple of them and see if somebody will come in on this, and then maybe you can figure out a way forward. Because again, I see what happened here. I mean, it happens a lot. But while you're here, let's see if we can get somebody else in and maybe talk to you. I'll call it back. So we're gonna check on the lawyers for funding, catch somebody, and see if anybody will come in to address this. So just hold tight now. Ma'am, I'll come back to
Okay,
you.
thank you.
Okay, you're welcome. All right, the court now calls case number 22-178029. This is Avis Rental Car Systems LLC versus Brandon Lipscomb. The matter is before the court on a petition for installment payments. Your appearance for the plaintiff in this matter, please.
Good morning, Your Honor. Mark Splain, appearing on behalf of the plaintiff, Avis Rent-A-Car Systems, P number 82148.
All right, thank you, counsel. Good morning to you, sir. I'm looking now for Mr. Brandon Lipscomb. I believe I see you there. Good morning to you, sir.
Good morning, Your Honor. Good morning, Mr. Swain.
Thank you, sir. All right, so you're requesting to make partial payments in this matter, I believe you requested $200 a month. Is that what you requested, sir?
Yes, initially that's what I requested. However, if it needed to be a little bit more to reach an agreement, then I'm open to negotiating if that's a proper term to use. I just didn't want to be garnished because it was taking a significant amount of my earnings.
All right, got you. So your garnishment rate, I know it's 25%, but how much, you get paid weekly, how much is that hitting your check for real dollar amounts?
You said how much is my check in dollar amount, Your Honor?
Yeah, on an average, how much do they take from you per week?
How much? So after taxes, my checks are usually around
Let me stop you.
800.
Let me stop you for a minute. So have you
Yes,
been
sir.
garnished? Have you been
Yes.
garnished at all? Okay, so
Yes,
each
but
week, that garnishment amount that they take out, how much is the garnishment amount?
it varies, but it's usually around $400.
Okay, so basically about $1,600 a month, somewhere in that neighborhood is what you're getting hit for, correct, sir?
Yes, sir.
Yeah, that's a huge garnishment. Counsel, defendant has indicated a petition for $200, and I believe that he's expressing that the garnishment as it exists is a hardship on him. Talk to me, counsel, and tell me what's the balance here, and what are you asking, counsel?
Right. So the judgment, the judgment was entered in back in 2022 for $9,687. We spoke with him to try to reach an agreement on a payment plan back in May of 2022, and then we couldn't come to an agreement. And now this is, we successfully garnished him, and now he's coming to the court for a payment plan. Our official position, Your Honor, is, we're fine. We're fine with a payment plan that benefits the defendant and us. So something that can get paid within a reasonable amount of time. We feel 200 is too low, especially considering how much he's making and the little bit of disclosed expenses each month. But a payment plan for 600 a month would get this paid off in a year.
All right. So,
May I ask a question?
Yeah, go ahead, talk to me. Let me ask you this. Then I'll definitely listen to your question. They're saying 600. Here's what I'm thinking. Now, you tell me if it's crazy. I'm thinking a wage assignment that will take $100 a week. That'll bring you to $400 a month. That makes sense to you?
Yes, that makes sense to me, Your Honor.
You have a question. Go ahead. What's your question that you have?
So when I initially began being garnished, I spoke to the payroll department at my job, and they told me that they held the funds for, I believe it was 28 days, because the person I had the opportunity to rebuttal, but I'm not sure if they have released the funds to the plaintiff, and I just wanted to know if they have released the funds and how much has been paid towards my balance.
That makes sense. That's why I'm just explaining about the balance and what you may have received, if you received anything from the garnishment.
So we have received, to his credit, he is correct. It's about 400 per garnishment. So we have received 1, 2, 3, 4, 5, about 5 garnished payments, totaling about, it's lowered his balance about 3,000.
So his balance is in the nature. What do you have now? You have somewhat nature of 6,000, or what are you, or 7? Where are you now? Roughly, maybe I may not be able to be precise today. Just a rough number. I'm just explaining as to where you are.
I'm sorry, Your Honor. I was distracted. Can you repeat your question?
Oh yeah, I'm trying to get a rough number that your office has in terms of what you believe to be the balance now with the application.
Oh, excuse me. Yes, hang on 1 second. Currently owes. If the garnished funds are released to us, that lowers his balance down to $6,066.
All right. So Mr. Lipcomb, that kind of puts you in the ballpark. There may be some interest that accrue on that over time, but that's about where you are right now. If those garnishments are released, and they will be released to the plaintiff. My order would certainly release them to the plaintiff. They will apply to your judgment, bring it down to $6,066. And then what my inclination is to put the payment agreement in place that will allow for $100 weekly by way of a wage assignment. So the order is going to say that they are to withhold up to $100 weekly. And so it will be an adjustment, but it's a wage assignment. So they'll be taking out the $100 a week and sending it to Avis on your behalf. All right. So you're gonna receive that order from me in the next few days. I'm going to start that order on the 12th of April, 4/12/24. And you may get hit with another garnishment before that date. That's why I'm setting it there. But in the next couple of days, you're going to get this order from me. You're going to take it to your payroll department as soon as you get it, and they'll know what to do from there. You understand?
So just to be clear, so I'll be continuing to get garnished until April 12th, and then I can take my payroll documentation.
No, you didn't hear me. You didn't hear me say that, but that's a darn good question. I suspect that you're gonna get garnished this week. Okay.
Okay.
You should get the paperwork and from me in time to stop the garnishment following this week. That would mean that you would not. That would mean that you would not garnish on the 5th, and then you would start making your payments on the 12th. You understand?
Thank you for clarifying that. Your Honor. If I may ask one more question, please.
Yeah, you have to pay extra for this one. Go ahead, sir.
Yes, sir. Now I'm paying everybody. Yes, sir. You got to pay the cost. Thank you. My question is, will I be making the payments directly, or will they be automatically withdrawn from my earnings?
That's a good question as well. That's why I talked about a wage assignment. I'm going to put in the order. It's a wage assignment. They'll take it out automatically and send it directly to Avis. All right. So that way you won't have to those logistics. All right. All right. So I wish you well. You'll get a copy of the order momentarily. Now, who do you work for?
I work for Chrysler. I believe the name now is Stellantis, or FCA, Fiat Chrysler Automobile. Deal in Dodge Ram.
Yeah, I got you. So I'm going to prepare an order that you're going to want to take to them, because you take that order to them, they'll know that they are to continue withholding. They may take $100 on the 5th of April. One way or the other, after this Friday, any payments that's taken after that should be $100 a week, and as opposed to what you're experiencing right now. You understand?
Yes, sir.
All right, I wish you well, and you'll get documents in the mail in the next few days. So, best to you. Thank you, Council. Good day.
Thank you so much. Thank you, Mr. Lipscomb.
Thank you, Mr. Swain. And Your Honor, will I be able to review this on the Register of Action, today's decision?
If you're sophisticated enough to do all that, of course.
I'm sorry, I'm not trying to bug you, Your Honor. I'm just trying to be responsible. That's how I got in this position in the first place, by not being, diligent about these things.
And you should be responsible. I'm not troubled by any questions. It will likely be on the Register of Action today, but if not, it will be very soon. And moreover, as quick as the mail can get to you, you'll get the stuff in the mail, because I got 2 documents that I'm preparing for you right now. You probably can see me holding them up. So you'll get 2 things from me in the mail. Okay, you take them to your. That's going to be an important piece for you to do, because that way the employer will have a court order reducing that garnishment down to $100 a week. Okay.
Understood. Thank you, Your Honor. Thank you, Attorney Swain.
Thank you.
Good day.
Yeah.